Welcome everyone to this Privacy Espresso. My name is Alessandro Di Mattia, Legal and Executive Officer at Privacy Rules. And today I'm joined by Jean Christophe Chevallier from the law firm Ydés, based in France, in Paris in particular. And we are going to discuss about the topic of the moment, that is the one related to the CNIL's position in relation to Google Analytics. Because this has opened a lot of discussion and there are lots of uncertainties. And today with Jean Christophe, that is an expert in privacy and data protection, we will delve a bit more on what it is about and what's the position and what should we do. So first of all, Jean Christophe, thank you very much for being with us today and for your time.
Thank you, Alessandro.
Okay, so let's start. The first question for you would be, can you give us a brief overview on what's the position of the CNIL, the French DPA, on Google Analytics?
Yeah, actually, the CNIL considers that the techniques, the legal and organic measures that has been taken by Google, especially the standard contractual clauses to correct the situation, were still not sufficient to keep away the risk for the European personal data processing by the American authorities. So based on this, the CNIL considered that the measures are still not legal, and any the Google Analytics has to be considered as a transfer tool, and based on the European personal data transfer is therefore illegal.
Okay, that's very clear. So is there any possibility to keep using Google Analytics, because many companies were doing that?
Yeah, actually, the CNIL was very particularly tough about using Google Analytics, and at the moment, most of the authorities consider that it is impossible to configure Google Analytics to make sure that there is no transfer of personal data outside of the EU, and there is no risk to have this personal data shared with the authorities in the US. So for the moment, there is no real possibility to keep using Google Analytics.
Okay. And what about the so-called Google Analytics 4, this new version of Google Analytics? Is it a viable solution?
If we are based on the last recommendation from the CNIL, Google Analytics 4 is not a real viable solution because the anonymization is not complete. Even if the IP address is no more collected with Google Analytics 4, the identifier like Ydés, are still collected by Google, thereby making it possible to identify the data subject. So we still are not sure that Google will be able to prevent authorities from accessing EU citizens' data, and the transfer outside of the EU remain possible with Google Analytics 4. So for EU controllers, it should be better to use an alternative solutions for the moment at the risk of receiving a sanctions, but this is a risk to be taken.
Okay, that's very clear. And what about the cases you had there in France? Did the CNIL issue any fine or related to that complaint? And if not, why? And if yes, why?
Actually, the CNIL did not issue any fine to any company, to my knowledge, but it has issued a lot of anonymized formal notice, which are only based to warm them up and put them under their obligations and ask them to comply with the regulation within 1 month. This 1 month period can be extended based on a specific discussion between the EU data, the recipient of the formal notice and the CNIL. And only the CNIL does not have this extremely aim to put sanctions. We understand that this is only formal notice that have been chosen instead of sanction. Because lots of controllers, website users, publishers use Google Analytics. The goal is only to raise awareness, but not to put sanctions for the moment. I'm pointed out for the moment.
No, that makes a lot of sense.
If a company receives a formal notice, it will have 1 month. If it is not able to comply with, then it will have to discuss and maybe ask for an extension of this 1 month period. And if there is no possibility to find an alternative solutions, then the CNIL, or if you don't put a good solution that the CNIL will agree on that, then the company will be exposed to the sanction.
Of course, but the approach makes sense since it's very difficult. It was very difficult at the beginning to find alternatives, but they are coming.
Yeah.
So that's definitely a good approach, probably from the CNIL, waiting for giving the companies the opportunity to change in this case.
Exactly.
And related to that and the CNIL position, Google in the meantime has provided certain measures, as far as I know, of protection, but these measures were not adequate, agreeing to the CNIL. So which were those measures, and why the CNIL did not accept them?
Actually, the CNIL is still not convinced about the anonymization and pseudonymization that has been proposed by Google as effective supplemental measures, because when they had analyzed the process of anonymization, they considered that, first of all, they understood that the anonymization proposed by Google was not applicable to all transfer, which is a problem. And the other point is that the unique identifier via the pseudonymization proposed by Google also still permit to identify the individuals. So based on this, the CNIL considered this is not sufficient enough. So they have to come back with another proposal.
Got it. That's very, very clear. So anonymization was not enough anonymized, let's say, in a shorter way.
This is the point.
And just one last question to open it to a broader audience that we normally have with privacy rules is how much this position is going to affect non-EU company, for example, US-based companies. Should also those companies already start applying the same approach that we are applying in the EU, so not using it or find alternatives?
As soon as a US-based company is using Google Analytics and is targeting European citizens or customers, let's talk with by customer stuff aspect, they have to bear in mind that these decisions is clearly applicable because it affects the possibility to use Google Analytics when they are operating and targeting these EU customers. So I would recommend them to maybe to modify their solution or maybe to implement internal very strong technical measures and of course legal measures such as the MCC clause, but not only because even if you have in place a BCR and MCC clause, as soon as you are using a tool that is running, that is, let's say, pointed out by the authorities as dangerous or illegal, then my recommendation will be try to find another solution to ensure and to apply to use such kind of tool without risking to have a formal notice coming from the European authorities.
Okay, perfect. Thank you very much, Jean Christophe, for all those clarification and these various questions that are helping us better understanding what's happening, what's the position of the CNIL, and also something that we can expect from other data protection authorities all over Europe, because it is highly possible we know that there was the Austrian DPA that was very much aligned to what the CNIL is now saying. So that's something that may not be new also in other countries in Europe. Thanks a lot for your time. We are running out of our time with this Privacy Espresso. I would like also to thank our listeners for being with us today. And of course, I would invite them to contact Jean Christophe Chevallier from Ydés in case of any need and support related to privacy and data protection matters. Thanks a lot again, Jean Christophe, and I hope to see you and all our listeners again next week with the next Privacy Espresso. Bye, everyone.
Bye.